Hello everyone and welcome back to another video at Lawsisto. In today's video, I'll be discussing a very important act which any employer, employee, domestic worker, a person who is working for someone else should know irrespective of your gender. And this act is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. This act is so important and it finally came into legislation after 16 years of the Vishaka's case. I have discussed the Vishaka's case in the previous video, so please do go check out. And let's get into this act. In this video, I'll be discussing about very important definitions, chapters and sections that all of us should know. So let's get into it. So now the protection against sexual harassment and the right to work with dignity are universally recognized human rights by international conventions and instruments. Now, one such convention is the Elimination of All Forms of Discrimination Against Women, which had been ratified by the Constitution of India on June 25th, 1993. Sexual harassment results in the violation of the fundamental rights of a woman. These rights are Article 14, which is equality before law, Article 15, which prohibits discrimination on the basis of religion, race, caste, sex, or place of birth, and Article 21, which provides her right to live and live a dignified life. Now, all these three basic rights are violated. These are basic fundamental rights that are violated. Along with that, it also violates her right to practice any profession or to carry on any occupation, trade, or business, which includes the right to safe environment, which is free from sexual harassment. Therefore, this is an act to provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of sexual harassment and for matters connected and incidental to that. To understand this act, let's discuss a few terms which have also been defined under this act. So the first term is an aggrieved woman. An aggrieved woman is a woman who can be of any age, whether she is employed or not. But if she alleges to have been subject to any kind of sexual harassment at the workplace, then she is an aggrieved woman. Second term is a domestic worker. A domestic worker is a woman who is employed to do any kind of household work and for which she is being paid. She can be hired directly or through an agency. She can be a full-time maid or a full-time domestic worker or part-time or on a temporary basis. But if she is being paid for her work, for her household work, then she is a domestic worker. The next term, which is very important, is sexual harassment. So it includes any one or more of the following unwelcome acts or behavior, and these acts or behaviors can be direct or can be implied. So these are a demand or a request for sexual favors, physical contact and advances, making any sexually colored remarks, showing pornography, any other unwelcome physical, verbal or non-verbal conduct of sexual nature. Any of these acts constitute as a sexual harassment. Now, next term, which is a very basic term, but it's very important for us to understand, which is workplace. Now, workplace can be any department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit which is established, owned, controlled, or substantially wholly financed by the funds of the government. It can be by the state government or the local authority or a corporation or any cooperative society. Workplace is also any private sector organization or a private venture. It can be again an undertaking, enterprise, institution, establishment, society, trust, non-governmental organizations, unit or service provider carrying on commercial, professional, vocational, educational, entertainmental, industrial, health services or financial activities including production, supply, sale, distribution or service. Workplace also is an hospital or nursing homes. It can also be any sports institute, stadium, sports complex or competitions or game venues. It can also be any residential which is used for sports activities which is related to training. It can also be any place which is visited by the employee arising out of or during the course of employment, including transportation by the employer for any undertaking such of journey. So all of this constitute as a workplace. I know it's a very basic term, but it is so important for us to know the meaning and what it is, what's its position in this particular act. Okay, now let's discuss Chapter 1, Section 3 of this Act, which is Prevention of Sexual Harassment. In this chapter, it tells us what constitutes a sexual harassment. So, if these circumstances occurs or is present, then it amounts to sexual harassment. So, first is explicit or implicit promise of preferential treatment in her employment, which means that there is a direct or indirect form of promise given to her that she will be preferred and she will be given more opportunities compared to her other colleagues. So if such a kind of a behavior or an act, whether direct or indirect, is given or is shown, then it amounts to sexual harassment. Second is implicit or explicit threat of detrimental treatment in her employment. This means that directly or indirectly she is threatened that if she does not perform that particular act or she does not act accordingly or as said, then she will be harmed and injured in her employment. Third is implicit or explicit threat about her present or future employment status. That means that her future or her present lies in the hands of the person who is harassing her. If she does not act accordingly, then she might get fired, and if she does, she might get promoted. So there is some kind of threat given to her that if she does not, she might lose her job. Interference with her work or creating an intimidating or an offensive or hostile work environment for her. If an environment where she's uncomfortable is created, then it also amounts to sexual harassment. The last thing is that humiliating treatment which is likely to affect her health or safety. So if any 5 of these are occurring or are present in the workplace, then it amounts to sexual harassment. Now, where should she go if these instances and acts are happening? So for this, the act states that there should be a committee created which should be known as internal committee and local committee. Earlier in 2013, when the act was created, it was known as internal complaints committee and local complaints committee. But recently they have changed this to internal committee and to local committee. Now let's understand what this internal and local committee are. So for every employer at the workplace, it is an order that they should in writing constitute a committee which is known as the internal complaints committee, now known as internal committee. This committee will have the following members nominated by the employer: a presiding officer who shall be a woman at a senior level at the workplace from amongst the employees, not less than 2 members from the employees, preferably who are committed to the cause of women or who have had experience in the social work or legal knowledge, and 1 member from a NGO. So these are the people who will constitute the internal committee, and half of them are supposed to be women. So now let's understand what a local committee is. So every district officer shall constitute in the district concerned a committee to be known as the local complaints committee. Now it's known as local committee. So in either of the cases, if the members are less than 10 people and because of which there is no internal committee, or if the complaint is against the employer himself, then the aggrieved women can make a complaint in the local committee. The local committee shall consist of the following members which are nominated by the district officer. The committee consists of a chairperson to be nominated from amongst the eminent women in the field of social work and committed to the cause of women, 1 member to be nominated from amongst the field who are working in the block, taluka or tehsil or ward or municipality in the district, 2 members of whom at least one shall be a woman, and she is nominated from amongst such non-governmental organizations or associations committed to the cause of women. One of these nominees should preferably have a background in law or legal knowledge. Now, let's understand what are the duties of the employer. This has been discussed under Chapter 6, Section 19 of the Act. There are 10 such duties. Let's understand these duties. The first duty is that it should provide a safe working environment. Now, this is not only restricted to the people who are working, but also for the people who come from the outside to the organization. So even for them, the organization should provide a safe working environment. Second, it should display at very visible places what are the penal consequences of sexual harassment. Third, it should organize workshops and awareness programs at regular intervals for sensitizing the employees and orientation programs for the members of the internal committee. The fourth duty is to provide necessary facilities to the internal committee or the local committee for dealing with the complaints and conducting an inquiry. The fifth duty of the employer is to assist the attendance of the respondent and the witness before the internal committee. It can be internal committee or the local committee. Let me clarify this here. Now moving on to the sixth duty, which is to make information available to the internal committee or the local committee as it may require having regard to the complaint. Seventh, provide assistance to the woman if she chooses to file a complaint in relation to the offence under the Indian Penal Code. So the employer should assist her in filing this complaint. The eighth duty of the employer is to cause and initiate an action under the Indian Penal Code against the perpetrator, or if the aggrieved woman so desires, where the perpetrator is not an employee in the workplace at which the incident of sexual harassment took place. The ninth duty is to treat sexual harassment as a misconduct under the service rules and initiate action for such misconduct. And the last and the final rule and the duty of the employer is to monitor timely submission of reports by the internal committee. So these are the duties of the employer, and these duties are given in this act with the main aim that the employer follows this and provides a safe working environment for women. Now, two things to remember here is this act also covers the punishment when there is a malicious complaint or a false evidence that is present by the aggrieved women, and there is a prohibition of publication or making known contents of the complaint and inquiry proceedings into the public. There is a penalty for the same. The information can only be publicized only when it is regarding the justice secured to any victim of sexual harassment under this act without disclosing the name, address, identity, or any other particulars calculated to lead to the identification of the aggrieved women and the witness. So this act was a much needed act for the country as it protects the women against sexual harassment at the workplace. Thank you for watching. Please do subscribe.